Hey guys, Tammy here, and today this is going to be part 3 of writing for court. Now, again, I know writing is something that almost everybody struggles with. I gave you 3 points in my first video. I gave you 3 points in my second video. Today, we're going to do the third set of 3 points. If you haven't watched the previous 2 videos, go back, watch the previous 2 because it's all just going to make a lot more sense if you kind of let it flow in that fashion. As always, if you are watching me on YouTube, please hit like on this video and also subscribe so you get notified as new content is released. And please also share my content. There's just so many people. I'm amazed, honestly, every day at the volume of people that are struggling to find help, struggling to afford help, a lot of them. And even when they can afford, I got a lot of clients that have like very top level attorneys, but they still don't have a fundamental understanding of what's happening because attorneys just don't generally break it down at that level, right? They kind of give you a high level, procedural, very legal answer to things, and you're left feeling like, I don't really know what that means. I still don't understand what's happening, right? So I'm going to try to fill in some of those gaps for you. Today, we're going to talk about part 3 of writing for court. Some of these are, a couple of these are just kind of a little more of like getting into the granular nitty gritty. And so that's why I say, if you haven't watched the previous 2, please do, because those have some of the higher level tips. So the first one today is know the rules. Okay. I talked to somebody a few days ago who had exhibits that they wanted to put into court, like, text messages and pictures and different evidence that they wanted to submit. And their hearing's in like a week. And I said, well, have you submitted those to the court already? And they were like, no. And I'm like, okay, well, you can't just show up day of. And they were like, oh, I can't? No, you can't just show up day of. You're not allowed to do that. You have to give the other side copies of everything that you're doing, and you have to file it with the court in advance, because the judges read these things the night or 2 at least before, if not even before that, but at least within a day or 2 before, they're reading everything and going through all of it. And a lot of times they will kind of make a preliminary decision, at least in their head. Some jurisdictions, they actually give preliminary decisions, but that's a different topic. But they at least kind of will decide in their head, like which way they're leaning or kind of what they're thinking based on everything they're reading. So you don't want to not have submitted it and show up the day of. But also, this is part of knowing the rules, right? If you're going to be self-represented, you have to understand what those rules are. I don't live in the state that she was in. I've worked in that state as a paralegal or legal document assistant like I do here. And so I couldn't help her, procedurally. I don't know, and so I said, look, you either have to go to the court and go to the self-represented help desk or talk to a local, paralegal or document preparer, or try to go onto the court's website and look it up, if you can find it. You have to know those rules. There are rules around timelines of when things have to be submitted, like these exhibits, like here in California, we have so many days for different things to be submitted. There's also page limits, certain declarations, depending on whether you're the person filing the motion or responding to the motion. There can be a 10-page limit, 5-page limit. Some jurisdictions don't have limits. I've seen states where there isn't a limit, which is unusual, but most of them do. We even have rules around the size of the font and the page line that the document starts on, and, the margins and all these different things that you have no way of knowing unless you go out and look up your rules of court from your county website to try to help you understand what all of these things are. So it's very important that you know the rules. There's rules around hearsay. You can't, again, it's different in every jurisdiction. Hearsay is when, like, I take something the child said to me and I say, oh, the child said, well, you can't say what the child said. That's usually hearsay. but it's very complicated. There's a lot of legal rules around that. And again, I'm not an attorney, but I'm just saying that it's important for you to know the rules. That's the important piece of this. Because if you don't, then you go in and certain parts of your declaration aren't accepted. Even your declaration itself, if it's filed late or over the page limit or different things, you run the risk of it being excluded from everything, right? So you want to make sure you know these rules and that you're following them. The second tip today is that you need to write in a neutral, child-focused way. Okay, so that means that you want to think of things in terms of, how does this issue affect the child? How does the thing that happened affect the child? Not what is the horrible thing that the other parent has done, which is how most people tend to frame it. So they want to say something like, the other parent never shows up for their visitation and, misses half the time and only shows up if they feel like it or they don't have anything else going on. Well, that's really writing it in a very attacking way that's focused on the other parent. Instead, you frame it something like, I'm really concerned because there isn't a lot of consistency in the visitation, right? See, I didn't name a parent. I just said there isn't consistency in the visitation. The visitation is the thing that's happening, right? And I'm concerned because the child really looks forward to the visits, asks about the visits, waits for the visits, and then feels very disappointed when the visits don't happen. And this really has a negative impact on the child. They get very upset, or they cry, or they have anxiety, or they, whatever it is. Learning to frame things in a neutral, child-focused manner with neutral language is, I think, a key critical skill in dealing with child custody, because you don't want the court to read your declaration and it just to read like, the other parent sucks, the other parent sucks, the other parent sucks, the other parent sucks, right? I've seen declarations like that where it's just paragraph after paragraph after paragraph of attacking the other parent. And that's just not helpful, because if the court thinks that for you, this is about the other parent and what they are or aren't doing, guess what? That won't be credible. And I've talked a lot about credibility in the last few videos. You don't want to frame things in a way that's going to hurt your credibility. You want to frame things in a way that's going to increase your credibility. How do you do that? By keeping it child focused, because that's what the court's focused on. The court isn't focused on whether you or the other parent are these horrible parents or fantastic parents or whatever. I mean, on a certain level, yes, they have to make sure the child's safe and all that kind of thing, but it's not a competition of who's the best or who's the worst. Okay, it's a competition of what is the best thing for the child, who's the most consistent for the child, who shows up, who follows through. Okay, so you want to keep your focus child focused, right? Not other parent focused. The other thing I think that especially self-represented people miss a lot is you need to tell the court what you're asking for. I've seen people write declarations and just be like, oh, here's all the problems, court. The child doesn't want to go, and, the child has anxiety and the other parent doesn't show up, and, there's all these issues. And then it's like, okay, there you go. And it's sort of like, if you think about that, it's like just dumping all your problems onto the court and going, okay, tell us what to do. I mean, you're the one that knows your family, and you're the one that knows your child and what may or may not solve some of these problems. You have to tell the court what you're asking for. Your Honor, I'm asking that the child be put in therapy to help deal with some of their anxiety and the stress that they feel. I'm asking that a parenting plan be put in place, and if the other parent doesn't, isn't consistent and misses one of their visitations, that the timeline to the next step up starts over. I'm asking that the other parent have alcohol monitoring because they have a history of drinking, and I'm concerned that they're going to drink and drive with the child or put the child in harm's way from their drinking. And so I'm asking that they have some sort of alcohol monitoring. Like, tell the court what it is you're asking for. I'm asking for joint legal custody. I'm asking for sole physical custody. I'm asking for a week on, week off parenting schedule. Tell the court what you're actually asking for. So many people do a narrative of complaints without actually saying what they want to have happen as a result. That's a really key thing. If you go back and look at examples from attorneys or even opposing counsel or whatever you have access to, you'll see at the end they usually write orders requested, and they'll give a list. Most of the time they will do that when they're writing a declaration for a motion. All right. I hope that this last set of tips has been helpful. I know writing is so challenging. There's just, I could go on and on and on. I mean, Thomas used to say he could teach a class for days on how to write. And I've learned a lot from him over the years of how to do that. But I hope this handful of tips has been helpful for you. If you'd like to learn more about my coaching services, please go to divorceuniversityonline.com/VIP-coaching. There's a link on that page. You can book a free 15-minute consult to talk to my staff to learn more about my coaching services and how we might be able to help you in your child custody case. All right. See you guys next time.
We'll grow in number, fueled by them to see the